Hey everyone, Attorney Matthew Legan Sanchez here. Today we're going to talk about enforcing and modifying a court order in Albuquerque, New Mexico. I'm standing outside a Second Judicial District Court today because sometimes your ex is going to refuse to follow your court order, refuse to play ball, and you're gonna have to get the court involved to enforce the court order. There's three major ways your ex is gonna refuse to follow a court order with a marital settlement agreement: with a home, with a car, or with support. With homes, possibly your ex is refusing to finance the home, refinance the home, they're refusing to take your name off of the title, or they're dragging their feet on signing all of the documents to prevent the home from moving as court ordered. With cars, potentially your ex is refusing to take your name off the title, to refinance the car, to get your name off of the car. Similar to home, with support, possibly your ex is not following the court order and paying child support, they're not paying alimony, or they're not making an equalization payment as court ordered. With child support, you'd file a motion to enforce, you'd file that also with alimony or with an equalization payment, and if they're not making those court order payments, you're gonna have to get the court involved and they're gonna have to enforce that court order. Maybe you're also having issues with your parenting plan. Your ex is refusing to follow the parenting plan, which is the court-ordered custody and time-sharing order. Possibly they're not giving you your time sharing as court ordered, they're not showing up at exchanges on time, they're not giving you your holiday or visitation schedule as court ordered, maybe they're not making the child support payment, possibly they're not doing the communication as court ordered through the parenting plan. If you and your ex can't agree on the court order, the first thing you should do is contact them. Set a clear deadline as to when they need to follow the court order by. They need to make the child support payment by this date, they need to pay alimony by this date, they need to make the equalization payment by this date, they need to get your name off the home or the car by a clear date. If they're still not following that clear date, if that date has been violated, then you're gonna need to file a motion to enforce. Just because your ex agrees to something now doesn't mean they're going to agree to something later. So if your ex is agreeing to a change in the custody or time sharing now and it goes against an old court order, you should get that in a document called a stipulated court order, which clearly modifies the old court order. It prevents future issues from maybe your ex saying, oh no, we didn't actually have that agreement, or saying that the agreement was something that it wasn't. Custody and time sharing court orders, they're not forever decreed in stone to where they can't be modified. Your parenting plan, it could be modified based on what's called a material change in circumstance, which basically means a big change in circumstance. Now, a material change of circumstance could be a relocation, it could be abuse and neglect, it could be issues in the other parent's home. Any number of big changes could occur that the court needs to look at and find that the old time sharing is no longer in the child's best interest, and there needs to be a change in the custody and time sharing to reflect what's actually the child's best interest. And if there is this change, you'd file a motion to modify with the court. The court could get to the bottom of what the change in facts look like, what the time sharing actually should be based on the change in circumstance, and get an appropriate time sharing schedule for your child. Child support can also be modified based on a material change in circumstance. This means a 20% change in 1 year. So if your existing support obligation is $500 a month, the change would have to be $100 up or down based on all of the factors, based on your gross monthly income, the time sharing, daycare expenses, or extraordinary expenses. A change in all of these factors leads to a 20% change in your existing monthly obligation, and 1 year has passed. If you can show those two things, then a court should modify your child support. It's important to consider that your child support is not modified the date that your time sharing or your income changes. It's modified to the date that you file the motion to modify. So it's very important, if there's been a material change of circumstance, you need to get that motion in there so it locks in the date that the child support can be modified back to. Do you still have questions about enforcing or modifying a court order? Take a look at my website, look at the practice area, look at the FAQs. There's a number of different questions and answers. Maybe it's going to answer your question, and if it doesn't answer your question and you still have questions, give me a call. Call Attorney Matthew Legan Sanchez. I'll listen to your case, I'll listen to your individual facts, and we'll get to the bottom of what's going on under New Mexico law.